Good afternoon. We are conducting first appearance hearings. There are 4 purposes for each hearing. First, I will advise you of the charges that have been brought against you by the state. Second, I will ask if you would like a lawyer to represent you. If you've already retained your own attorney, please advise me. If you would like to have your attorney present with you, we will attempt to make those arrangements for you. If you want a lawyer appointed by the court to represent you, then I'll ask you some questions pertaining to your financial situation to determine if you meet the statutory criteria for the appointment of the public defender's office. Please be advised there's a $50 application fee for applying for those services, and the court may require you to pay reasonable value for those services. Third, I will determine if there's probable cause to hold you for your arrest. That means there are reasonable grounds to believe that a crime may have been committed and that you are the person who committed the crime. The fourth purpose for this hearing is to review your bond status. In some cases, the bond set for you through book-in might be too high, and in other cases, it might be too low. Each of you has the right to remain silent. Anything you say can be used against you. There's an assistant state attorney here listening to everything that is being said, and it is all being recorded. So please do not say anything about the facts of your case or the crime itself. The questions I'll be asking you pertain to whether you want a lawyer and to review your bond. You may refuse to answer those questions. You have the right to communicate with your family, friends, and with your attorney. I ask you to keep these rights in mind, and when your name is called, please step forward. Tony Wiggins.
In Your Honor, Sandra Smith, Public Defender's Office, on his behalf, I would like to waive the reading of his charges.
Mr. Wiggins, are you aware of your charges?
Yes, ma'am.
Do you have an attorney to represent you?
No, ma'am.
Would you like an attorney to represent you?
Yes, ma'am.
Are you employed?
No, ma'am.
I'm going to appoint the Public Defender's Office. We have an assistant state attorney with us, Mr. Wallace.
No, Your Honor, this is Mr. Tony Wiggins. Is that correct?
Yes.
Yes, it is.
Yes, Mr. Tony Wiggins is already represented by Guy Bradstock on a previous case, so we have no objection to the Public Defender's Office being appointed.
All right. I have reviewed the probable cause and find probable cause. As to the 3 counts, counts 2, 3, and 4, you're being held no bond. As to count number 1, State, do you have anything for the bond on count number 1?
No, Your Honor, that for that count, we have no objection to a standard bond.
The bond on that count is $5,000. Additionally, you have open cases MM20 2763, CF20 2134, CF20 5613, CF20 5654. Your bond is being revoked.
Your Honor, Sandra Smith on his behalf, he had previously come to first appearances earlier this week on July 21st. And the judge already parked him on 20 CF 2134XX. The other charges were new charges. I don't know that Parker would apply to those.
When did the charges state?
Judge, the CF 202134, the defense attorney is correct. I think on that one he was parked earlier this week. The CF 205613, those charges were just brought this week as well. And I think on those counts, he has previously been given a bond of $15,000 on the possession of firearm by convicted felon and $5,000 for the possession of ammo by convicted felon. And the state has no objection to those remaining the same for those counts.
The Mr. Wiggins, the bond on the possession of a firearm by a convicted felon is $15,000. Possession of ammunition is $5,000.
Yes, ma'am.
Anything further from the state or defense?
Not from the state, Your Honor.
Nothing from defense, Your Honor.
Thank you, Mr. Wiggins. Mary Whitmore,
Your Honor, Sandra Smith on her behalf, I would like to waive the reading of her charges.
are you aware of the charges that are filed against you, Ms. Whitmore? Ms. Whitmore? Are you aware of the charges against you?
Yes, ma'am.
Okay. Do you have an attorney? Would you like an attorney? Are you employed?
Yes, ma'am.
I'm going to appoint the public defender. I have reviewed the probable cause and find probable cause. State, as to the bond amounts,
Your Honor, as to Mary Whitmore, the state would request that the standard bond amounts be set for each one of the 3 counts against her. But I would also like to be heard as far as the appointment of counsel. Ms. Whitmore is, her charges directly relate to the charges of first-degree murder by Tony Wiggins, which is in CF 205654. Mr. Wiggins is represented by the Public Defender's Office. There, in our opinion, is clearly going to be a conflict for Ms. Whitmore. She does qualify for the appointment of counsel, but we would request that at this point, rather than appointing the Public Defender's Office, Your Honor, appoint a private attorney to represent her, who's someone who accepts appointments. And Judge, the reason for that, if I could explain, is Ms. Whitmore is under a investigative subpoena by our office to be questioned tomorrow morning at 10 a.m. That was served this morning to allow her 24 hours to make sure she was aware of it. So our intention is to speak with her under subpoena tomorrow at 10. And we do want to make sure she has an attorney that doesn't have a conflict. So that would be the purpose of my request, that Your Honor appoint a private attorney that would allow me to communicate with that person this afternoon. They would have an opportunity this afternoon or this evening to speak with her prior to the 10 a.m. Investigative interview tomorrow.
And Your Honor, I would ask that the Public Defender's Office be appointed through the proper procedures. We will look into conflicts, obviously, and it would need to go to regional counsel after that, and then they would look into their conflicts as well. That's the proper procedure in these cases.
and Ms. Smith, as to the issue that she is under subpoena for 10 o'clock tomorrow,
I have nothing to say about that, Your Honor.
the state has requested a private attorney. As there is going to be a conflict from the Public Defender's Office, I am going to appoint a private attorney that accepts appointments. Madam Clerk?
Judge, that's not something that the clerk's office completes. That comes from your office by order. So if you want to contact or want me to contact your JA and get an attorney off of that list, then I'll be more than happy to do that for you. But we don't have the list in our office.
Okay. And if you can, you will contact another Judge Harb's JA?
Yes, ma'am.
Okay. All right. All right, I have reviewed the probable cause, find probable cause. Your bond amount for all 3 counts is $15,000 each. count. If you do post bond, you'll be on pretrial release conditions. Conditions of pretrial release: will not use, possess, carry any firearms, guns, weapons, ammunition, or knives. You are prohibited from having any intentional contact with the victim's family, identified either directly or indirectly, in person, in writing, by phone, pager, fax, text, email, or through third person, except for scheduled court proceeding. You must stay 500 feet away from the victim's family, home, vehicle, place of employment, and/or school at all times. You will have no contact with any co-defendant listed in this case. You will be on GPS monitoring to be fitted before release. Anything further from the state?
No, Your Honor.
Judge, if you want to hold her for just a moment, I'm on the phone with Judge Harb's JA, just so I can get clarification before we release her.
And on the GPS monitor, you're permitted to leave for attorney's appointment only. Just a minute, we're getting a name for you.
Judge, hold on. I'm on the phone with Cindy from Judge Harb's office. He requested that you take a brief break so he can speak with you. I'll take us off record.
Thank you.
I'll bring us back in when she comes back in, but this is a classic. Hold off for 1 second before you release her. We got some information you need to know. What's up, girl?
Where's Mom? Is it gonna be home?
They went shopping.
Well, aren't they gonna be home?
They went shopping.
I know.
Well, Isley has dance at 4 o'clock. So they have to be home by then. I'm on a live. So take a hike, missus.
No.
Yes.
I'm hungry.
You're hungry. What do you want? Are you starving?
What's for lunch?
You didn't get lunch? I saw you had bagel bites earlier. What
That
else?
was that was breakfast.
You had bagel bites for breakfast?
Yep.
At like what, 11 o'clock? Maybe. What do you want for lunch?
I don't know.
You don't know. You don't know.
Depends what we have.
All right, give me just give me a few minutes and I'll get you lunch. Fine, she
What
says.
I want for lunch, I don't want our food. I want Arby's.
Oh, now you want Arby's, huh? Mom's got some sandwiches in there if you want a sandwich.
I just want Arby's.
Arby's.
Plus, I want our food because I'm cold.
What do you want? Like a little slider from Arby's?
I want roast beef slider
Roast beef slider
and fries.
and fries. That's it?
Yeah.
If you get that, you're going to be super happy?
Yes.
Okay.
I'm not gonna see, but
That was easy. I'm going to be an Arby's go-getter. Oh. She doesn't have a record, but what's going to end up happening is the judge has got something for her. The judge is they're going to try to make a deal with her, or some of you have thought they made a deal with Rob, the other guy. Here's the deal. It doesn't matter who's getting the deal. TJ's going under the jail. The question is, he was out on bond. It sounds like he was out on bond with this thing. I'm not 100% because they didn't read the charges, but it really sounded like he was already out on bond when he committed this. And if that's the case, then this needs to be a poster case for what's wrong in today's judicial system. You know, we will let murderers and guys with 230 plus felonies out on bond. I don't even want to tell y'all how they treated Dad with a phone. Shoot, I get all my charges dismissed because they're just harassing me, and they hold me 10 days without a bond. Man, how broke is our judicial system? Straight up broke. But I don't know why I'm waiting for this judge to come back, because I can skip ahead. Let me see what's up here. This is prior recording. Did they ever come back? Here we go. Here we go. Here we go. Yeah, forget all that. We'll just skip ahead. Let me see when they're going to come back. Okay.
Okay, good.
Who's this cat?
What did you say about cat?
Judge, you want me to put it back on?
Yes, please. Are we on?
We're on, Judge.
Miss Mary Whitmore. In speaking to the judge that typically handles these, I'm going to appoint the public defender's office. Is there anything further in this case?
No, Your Honor. The only request I would have is that the public defender's office, if they're going to withdraw, file that motion immediately. If not, I would give them notice that we're going to be speaking with Ms. Whitmore tomorrow morning at 10 a.m. at the Sheriff's Department, and they need to be there. And I'll provide them a copy of the subpoena that's been served on her.
Thank you. Thank you, Ms. Wiggins. Whitmore, excuse me, Ms. Whitmore. William Wiggins.
And Sandra Smith with the defender's office on his behalf. I would like to waive the reading of his charges.
Just wait a minute real quick.
Okay, go ahead.
Yes, sir.
Did he hear the advisement in the beginning?
No, ma'am.
We are conducting a first appearance hearing. There are 4 purposes for this hearing. I'll advise you of the charges that have been brought against you by the state. I will ask if you would like a lawyer to represent you. If you've already retained your own attorney, please advise me. If you would like to have your attorney present with you, we will attempt to make those arrangements for you. If you want a lawyer appointed by the court to represent you, then I will ask you some questions pertaining to your financial situation to determine if you meet the statutory criteria for the appointment of the public defender's office. Please be advised there's a $50 application fee for applying for those services. The court may also require you to pay reasonable value for those services. I will determine if there's probable cause to hold you for your arrest. That means there are reasonable grounds to believe that a crime may have been committed and that you are the person who committed the crime. The fourth purpose for this hearing is to review your bond status. In some cases, the bond set for you to book in might be too high, in other cases, it might be too low. Each of you has the right to remain silent. Anything you say can be used against you. There is an assistant state attorney here on the phone listening to everything that is being said, and it is all being recorded. So please do not say anything about the facts of your case or the crime itself. The questions I will be asking you pertain to whether you want a lawyer and to review your bond. You may refuse to answer those questions. You have the right to communicate with your family, friends, and with your attorney. I ask that you keep these rights in mind. Mr. Wiggins, are you aware of the charges that are against you?
Yes, ma'am.
Do you have an attorney?
No, ma'am.
Would you like an attorney?
Yes, ma'am.
Are you employed?
Yes, ma'am.
And how much do you make per week?
$4.50.
I'm going to appoint the public defender's office. I have reviewed the charges. I have reviewed the probable cause and find probable cause. State.
Judge, we have no objection to the public defender's office being appointed and him being found indigent. I would ask that the standard bond amounts be scheduled for all 4 of his counts.
Count number 1 will be $1,000. Count 3 through 4 will be $15,000. If you do post bond, you'll be on pretrial release conditions. Conditions of pretrial release: you will not use, possess, carry firearm, guns, weapons, ammunition, or knives. You are prohibited from having any intentional contact with the victim's family identified, either directly or indirectly, in person, in writing, by phone, pager, fax, text, email, or through third person, except for scheduled court proceedings. You must stay 500 feet away from the victim's family, home, vehicle, place of employment, and/or school at all times. You shall have no contact with any co-defendant listed in this case, and that would be specifically Tony Wiggins or Mary Whitmore. You'll be on GPS monitoring to be fitted before release. You are permitted to leave for attorney's appointments only. Anything further?
Not from the state, Your Honor.
Nothing from defense, Your Honor.
Thank you, Mr. Wiggins. All right. Next, we have Mr. Cohen.
Your Honor, Lee Cohen for Chrissy Perry in 18 CF 8411. Your Honor, we're going to waive a reading of the allegations of violation of probation. Ms. Perry is aware of those. Additionally, Ms. Perry reported to her probation office knowing that there's a warrant.
So it looks like that is the end of the pre-arraignment. There's like 6 minutes left. They're going to arraign some other people that I don't necessarily care to have to listen to. I wanted to listen to these 3 arraignments and see how they went. I think both these people are going to end up getting talked to by law enforcement. I don't think anyone has flipped as of right yet. I found it interesting that the judge switched her stance. She originally was going to issue private counsel to the girl, and then because that was something they wanted, and then another judge got in and said, "Hey, no, we don't want that." And so I find it interesting that got switched afterwards. It'll be interesting to see what they talk to her about, what she says, what kind of deal they offer. I can tell you this. She has like small children, and I think she has children with this dude. It's just sad. It's sad to think that yet every one of the victims' lives is going to be affected, but also every one of the suspects, their families are affected too, good, bad, or indifferent. There's just a lot of people that are going to be affected in this case. There's a lot of moving parts. I think they're going to end up probably giving one of these two suspects a deal of some sort. I think they may all do some sort of prison or probation time, depending on what they did. If the girlfriend knew about what happened but didn't, that I think they charged her with like tampering with evidence or stuff, something like that. And I'm not 100% sure on the exact charges they gave her. But if she wasn't there on location, but she was probably there because it was minutes after the general store. So who knows? I think they all should be charged. If they were on location when the murder went down, I think they should be charged with murder. If it's something where he gave her the gun to get rid of, maybe you could make an argument for a deal. Maybe you could make an argument for some sort of reduced deal. But if they were all on location, which I don't know the details of that. I haven't been keeping up with this all day long, so I don't know what I could go back and listen, but if they were on location when it happened, slam them all. If it was a deal where he gave her the gun or he gave him the gun and they're going to roll over and snitch on him and it makes it easier to convict him, I don't know why you couldn't convict him now. It sounds like this dude is an A1 number one list. Dude, 230 felonies? What kind of screwed up system are we living in? That this dude was even out. I mean, that's another whole criminal case in and of itself. That's a whole nother subject. So the question is, yeah, if she admitted to buying ammo, right? If she bought the ammo, but it depends. Was that bought like the day before or was it bought weeks and weeks before, I think they could all go down. I'm all down for taking them all three down, but I really think people ought to really consider some things. One, depending on what her involvement was, right? If she bought the ammo 2.5 weeks ago for this dude and all of a sudden he kills somebody, I don't necessarily see her, but she's on the Dollar General store video. So if she's in the truck and he does it, slam her. If she's in the location or on location, slam her. If he takes her home, drops her off in the 10 minutes, and then he goes out and does the murder and comes back, and she bought the ammo that he used, you know what? If she doesn't cooperate, slam her. If she cooperates, maybe you give her a chance and it teaches her kids, hey, you got to choose who you're going to hang around, I don't know. I don't know the details of their involvement. They didn't this wasn't something they had a chance to like clean up. They didn't go back and clean up. So depending on how it all went down, but if she's in the truck and it goes down, I mean, I gotta believe unless she went straight to law enforcement, right? If she turned around, he drops her off and says, "Don't say a fucking thing," and drops her off at the house, and she calls the cops and says, "Listen, this is what happened. This is what went down." Then no, don't charge her at all. But if she held out for 3 days and waited till she was arrested to say anything, you got to put that girl in jail for a little bit. You got to put her in jail for a little bit. If all bodies were at the scene and they didn't immediately escape the presence of TJ and go to law enforcement, then fry them. Fry them all. It's all right. We'll be okay. Her children will be adopted by a loving family, and they'll move on with life. But too many loving people in the world that you can't just say, hey, because she has children, let her out, because you may not want her raising those children, and I'm not the one to say that, because I think that's the greatest responsibility any person is given, and I don't think anyone should be able to take that right away unless you start killing people. You start killing people, hey, you might not be fit enough to be a parent. Even though the evolution allowed you to reproduce, you may not be fit enough to be a parent of children. So it is what it is. Hey, they got a it sounds like they got a slam dunk case on them. So this looks like it's going to be a pretty slam dunk up and down case on at least a couple of them. Hopefully all of them do some time, especially if they were all three on the scene. If they're all three there and they didn't immediately somehow escape what was going on and go to law enforcement, then I got to believe, listen, put them all on trial. If, somehow they come up with an elaborate story how TJ held them hostage and that's why they didn't go to law enforcement, then really check that story. But, I just feel like if they were on the scene and didn't immediately go to law enforcement, then, and I don't even think they should get out of it if they went straight to law enforcement, because they could have stayed there and stopped the bleeding. You know what I'm saying? And so, they all probably need to do some sort of time for sure. Well, TJ for sure, he needs to just 200. That's a broken system, dude. 230 times. 230 times, and he's walking the streets on bond. $230 times. I can't even imagine. Thanks for watching Dad with a Phone. That's been fun.